Talking to you.
So Sneha, let's wait for a 5 minute. One more participant is planning to join. I think so he's busy.
Sure.
Yeah.
I hope we can record this session, Akshay, for future
I'm
reference.
recording it. I'm recording it.
Okay, good.
Yep.
Akshay, what is this read.ai?
That is a you can say a um, AI kind of a platform where we can get a summary after meeting. We can get a summary of the meetings. What are the key highlighted points? मैन्युस्क्रिप्ट ट्रांसक्रिप्ट वो सब उसमें बनता है तो
Oh,
वी
wonderful.
जस्ट ऐड हाँ तो टीम्स में वो ऐप रहते हैं तो ऐप में वी हैव टू दिस रीड डॉट एआई के ऐप है वी हैव टू ऐड इट एंड वी हैव टू स्टार्ट इट वी हैव टू ऐड इट एज अ attendee
Yes.
in meeting and so right now I can see whatever we are talking I can see in this transcript in my
Acha.
window
Okay.
summary वगैरह बहुत
Right.
कुछ है
Very good.
हेलो हाँ ज्वाइन करो ना Okay. So, Sneha, I think all the participants have joined. So, participant, let me introduce you to Sneha. She is a member of the estate planning team of the private wealth. And today on, I request her to guide us regarding the how the exactly the private wealth team execute the estate planning and will creation for the client and what are the key benefits. So, Neha, if possible, can you drive us the entire concept? I think earlier Hitesh drive it, but that was with another individual. So all the three participants are unaware about the process and benefits of regarding that. Plus, we have some questions regarding that. Basis the individual to individual. So we can also take that. So first, can you drive us to the benefits and features of the estate planning and migration?
So firstly, I think I should take you through the will as a concept, right?
Perfect.
So okay. So I'll just share the sample draft that we used to make a will. Just a
Hmm,
second.
hmm. So today we have to cover the will as well as trust.
Okay.
Yeah.
First, I'll go through the we'll go through the will aspect. Just a second.
No issue.
I'm not able to share my screen.
Let me just give you rights. Yes. Now you can share.
Okay. No, I still can't. It's not letting me.
Just a second. Hmm. Now you can.
Hold on.
Hmm.
There's some issue. I'm not able to share my this. But okay. In the meantime, I'll just explain how our draft will
Mhm.
looks like.
Okay.
Hold
No
on.
issue. Meanwhile, I have the
Okay.
trust regarding the presentation. Shiv. Actually, you
I
are sharing that.
Now is it visible?
Yeah, yeah,
Yeah,
yeah.
it's visible.
Huh. Okay. Okay. So this is how our will draft looks like. Um, we firstly we mention the person's name. Okay, like whatever your name is. Then your father's name. If it is a woman, we mention wife of Mr. So and so. Then we mention the date of birth and the residential address. Now, all of these details are as per Aadhaar card, right? And what we say in the first paragraph of the will is that this particular document that you are making is your final will and codicil. And if you've made any will and codicil before this, then all of this stands revoked by virtue of this particular document. So, so this is just for your information that a will can be made n number of times, can be edited n number of times. Okay. Your entire property is divided into two parts. One is your movable assets, and one is your immovable properties. And whatever assets that devolve through this will, it is after your debts and liabilities are subtracted. Whatever remains of your estate after your debts and liabilities are subtracted is what goes through this will. Okay. Any questions still here? Is it clear?
Yeah, yeah.
So the next part that we talk about is we divide the movable assets further into your financial assets. So whatever financial asset, the asset classes are mentioned here. You can see mutual funds, structured products, bank accounts, demat accounts. So we don't mention the details of your financial assets. We just mention the asset classes because financial asset, the details are very dynamic in nature. Like your account numbers can keep changing, or your demat account number can, you might close it. So we don't mention
Hmm.
the finer details of it. We just mention the asset classes, right? And then what we generally do is we make something called as a crisscross will, where if suppose there is a husband, whatever he owns goes to his wife on the first level. Like after him, everything goes to a wife. And if there's the wife's name mentioned here, then everything will go to the husband, to the will. Okay, so this is the pattern we generally recommend and follow. But of course, you can give it to anybody whom you desire on the first level, right? So this is the financial assets part of it, where we mention only the asset classes. Then we move on to business shareholding. Now this is only applicable to those
Sneha,
people.
I have one query here. What
Huh.
is the significance of the yellow highlighted portion, PF, pension, gratuity, and all of that?
So certain clients don't own these assets, which is why we put it in yellow so that if the client wants, they can delete it.
Okay.
So this is just for we ask the client if they own any of these assets, and if they are not there, so this doesn't have any significance per se. It's just for our reference where whenever we have a meeting, we ask, like when we are
Got it.
finalizing or so,
Got it.
because a lot of clients don't have like a lot of clients do have bank accounts, demat accounts, but some people don't have pension or some people don't have gratuity. So we ask and we delete accordingly.
Thanks.
So,
Okay. Okay.
so the second part is business shareholding. Now, this is only applicable if you have a business, if you own a business. So what we do is in these columns, we mention the name of your entity. So we mention whether it is a sole proprietary or a partnership firm or a private limited company or an LLP. And here also we say the same thing, that it goes to your spouse after you, right? This clause is only applicable if you own a business. Then the third part is your bank locker and jewelry. So if you have a bank locker and if you have contents in it or you have any jewelry in it, so we say here that all of that will go to your spouse. Again, this is all customizable. If you don't want to give it to your spouse, if you want to give it to anybody else, that we can arrange for that as well, right? Then we move on to this part where we say miscellaneous assets. So let's say if you have any watches or you have any vehicles or you have any personal documents or anything which is not covered in the above clauses. So whatever that is, that we cover it here in the miscellaneous assets clause, and we say that that goes to your spouse. Then we have the HUF part. Now, even this is only applicable to those parties who have an HUF. So if you don't have an HUF, we will delete this particular clause. So in an HUF, we say that your share in the HUF. So if you're aware of what an HUF is basically Hindu undivided family where each member in the family has a particular share. So we say that your particular share, whatever you own in the HUF, will go to your wife. Then we have this part where we mention expected inheritance. So let's say if you're expecting inheritance from any relative, or if your parent is alive, you're expecting from them, or if there's any expected inheritance. So we don't mention the details of the expected inheritance. We just mention from whom you're getting the expected inheritance and that person's details here. For example, if I am getting expected inheritance from my father, I will mention his name, his date of birth, and his residential address, and then I say it will go to my spouse, for example. Is it clear till here? Any queries?
Yeah,
Yes,
perfect.
clear.
So this was all your movable assets. Now we move on to the immovable properties part of it, where we mention your property's complete address that we will require here. Then we mention the particulars of the ownership of the property, if it is singly held by you, if it is jointly held by your spouse or with any other relative. And then here we mention that it will go to your spouse, or if any other person, then to that person, right? So we mention like if you have one property, two properties, so we can add accordingly whatever number of properties you have, right? Then we have something called as residuary assets. Now, let's say if you acquire any assets in the future, right? Or if you have any assets at present, but let's say if we miss out on something. So this clause covers all of those assets, and where we say that if any assets are not mentioned or if any future assets are there, then that also goes to the spouse with absolute rights, right? Understood?
Yeah.
Any queries?
Yes.
So unforeseen eventuality here. So let's say in all of the above clauses we have mentioned to the spouse, to the spouse, to the spouse. Now what if before you know before you die, or like before the spouse dies, like if the spouse predeceases or passes away simultaneously, or let's say sometimes what happens is when the will is executed and the bequeathal process is in place, then the person dies, let's say like the spouse dies. So in the absence of the spouse, we have the second level beneficiaries. Now, generally for most clients, what we do is if the spouse is not there, we mention the name of the client's children over here, right? So it can be the client's children, or if let's say if you don't want to mention the children, that there's somebody else you want to give, so that person's name can come here. So here in this case, because our sample draft has equally to my son, Master, Mr., and my daughter, Miss, Mrs. So if you have only one child, only one name will come here and the assets will completely go to them if you want to. Or if you want to give it to somebody else, then we can mention the distribution accordingly. Right? Any queries?
Neha, a query here.
Huh?
Could you please explain once again the point regarding the bequeathal part?
Right. So what happens is, let's say if the person who's made the will is not alive, right? So the transmission process starts of the assets in the will. So let's say if the spouse dies when the transmission process is on, right?
Okay.
Then another person will get, so because if the legatee is only not alive to get the assets, we will need to mention somebody else's name, right?
Right.
So
Okay.
that is what we are covering here, right?
Okay.
Okay. So
Yeah.
is this
Thanks.
understood? Is this clear?
Yeah.
So then the next part, this is also only applicable if you have a minor child. Minor child is any child who's under 18 years of age. So let's say if you have a child who's under 18 years of age, you appoint a guardian for that particular child. So just for your information, till you and your spouse are alive, you are the natural guardians of the child. So this clause is only going to come into force if both of you are not there and if the will comes into picture. And also this is
And
only meant
simultaneously
for,
child is a minor.
sorry?
And simultaneously child is a minor.
Yeah, simultaneously child is a minor. Otherwise, let's say if your child is a major, we don't need this clause. This is only for minor children. Okay. Then the next part of the will is the executor part. Now, executor is basically the person who takes care of the transmission of assets through the will. So let's say when the will has to be executed and enforced, the executor is the one who makes sure that all the formalities are done basically. So what we recommend is that an executor should be the beneficiaries themselves. So let's say if in your will your spouse and your children are the beneficiaries, so they should be the executors in the will. And the simple reason for that is that let's say if you're getting something out of the will, you will execute it quickly, right? Because if you appoint a third person, then that person might not take so much of interest in executing the will, and it might delay the process. So which is why we recommend that you keep your spouse and your children as the executors. So here we have two levels, right? So on the first level, we have the spouse, and let's say if something happens to the spouse, or if the spouse is too old, or if she's not able to execute the will, then both the children can execute the will. So generally, what we say is if you have two children, then you make them joint executors. Or then then it's your wish if you don't want to make them joint executors, but we recommend to make joint executors, because if there are two beneficiaries on the second level, like we saw here, where if we are saying after the wife everything goes to my two children, so then keeping them here also as joint executors makes sense because both of them are benefiting from the will, right? So this was the final clause. Then we just move on to a standard clause where we say that you have executed this will without any coercion, threat, or undue influence, and that you are in a sound state of mind and that you're fully aware of whatever statements you've made in the will, right? Then here you are supposed to we mention your name, your full name. You are the testator. So basically, testator is the person who makes the will. So in your will, you are the testator, right? And then here two witnesses will sign. So this particular document, for the authenticity, we need two witnesses to sign here at the bottom, right? So this
Okay.
And
was
who's the
And that
legatee?
witness
sorry.
should not be from the beneficiary, right?
No, the beneficiaries cannot be the witnesses
And is there any
legally.
requirement of the lawyer and doctor's presence while signing the will?
So doctor's certificate is mandatory in Mumbai. You need
Hmm.
to have a doctor's certificate stating that you're in sound state of mind and that you're physically and mentally fit to make the will.
Hmm.
And what we say is that the doctor certificate should not be older than 24 hours from the date. So generally,
Oh.
we advise clients to register the will because that adds to the authenticity of the will. So
Mhm.
legally in India, it is not mandatory to register a will, but we advise to register it because it adds to the authenticity. And let's say if you misplace the will, the sub
Hmm.
registrar will have a copy of it.
Hmm.
So it's
But
advantageous
but
that way.
but registration will involve a cost.
So it does involve a cost, but it is recommended that you do it because
Okay.
rather
Now,
than sorry.
sorry, no problem. If we notarize it,
You can notarize it.
yeah, no, no, what I'm trying to ask you is if we get it notarized, in
Hmm.
which scenario will there be a problem? It is contested. If it is contested, it will be a problem. And if it goes smoothly, then there is no problem in a notarized will. And then if at all it is contested, the registered will stand a better chance? What is the, in which scenario will registered will be at advantage?
So let's say if there's a contest,
Yeah.
then it will prove to be more authentic. But if you're no, see, some people what they do is they just take a printout of this particular document. They sign,
Yeah.
they make two witnesses sign, and they staple a doctor's certificate and they keep it. So that
Yeah.
is the most, matlab, that is also perfectly legal. Like you need not do anything. But what
Okay.
happens is, if authenticity comes into the picture, either a
Mhm.
registered or a notarized copy gets more, it is more authentic. So
Okay.
either of these.
What I'm trying to ask you is, if somebody just writes it on a paper, as you said, and keeps it,
Hmm.
will it stand in court of law? Suppose it
Yes,
gets
yes,
contested.
yes, yes. See, you will have to prove in the see legally what happens is, if let's say there's a will with two, so like for example, if I print this particular document, I don't notarize, I
Yeah.
don't register, okay?
Okay.
But I have the two witnesses who have signed. I have a doctor's
Yeah.
certificate stapled, okay? So then the
Okay.
person who is dragging me to court, it will be on him to prove that this is not authentic, not on me.
Okay. Mhm.
So the burden of proof is on that particular person. That particular person will have to prove, because I have followed all the formalities. I have mentioned. So see, for any will, so let me clarify one thing. For any will to be valid, two witnesses have to sign, and a doctor's certificate has to be there, irrespective of registration. You can't
Okay.
just print a copy and not have any signature and say that this is a valid will. It is not a valid will. It will require your signature, two witness ka signature, and a doctor's certificate.
Okay.
But if somebody is dragging me to court, then it is on them to prove that this particular document, if I have followed all the formalities, is not authentic.
Okay.
So if you have missed out on signing, of course he can challenge, saying that there is no sign on it. How do we prove it? So
One more thing, yeah,
yeah, tell me.
yeah, one more thing. In initial part, you told that will can be revoked. The earlier one can revoke the previous one, right? So in
Right.
case of I notarize it or register it, can it get revoked?
Yeah. You can
Oh,
re-register or re-notarize. See, because there is one
okay.
thing. See,
Hmm.
at the bottom, if you will see, there is a date over here on the this day of 2020. So
Hmm.
whatever is the most latest date, okay, that
Hmm.
will be considered. For example, if I make a will today, 12th November, right?
Hmm.
And then 3 days later, I say कि नहीं मुझे ये नहीं चाहिए, मुझे दूसरा will चाहिए, and I make one on 15th. So
Hmm.
if I have mentioned the date of 15th नीचे here, if I
Hmm.
say 15th day of November 2024, then 15th November ka will be the one that will be considered.
But that has
Okay.
to be re-registered.
Yeah, then that has to be re-registered or re-notarized, or then you have to print it out again and sign. See, if you're registering once, then we would recommend to re-register it rather than registering it once and then वापस printing out and just keeping, because then
Hmm.
that can lead to मतलब, anybody will ask that why did you first register, and then when you had to make a change, then why you not
Yeah.
re-registering?
Yeah.
That
Exactly.
can
But
get
then
a bit.
if I re-register it, the expenses, whatever we have incurred the first time, will again the same type of expenses will have to do the same type of
Yes,
expenses again.
yes,
Yeah.
yes.
Okay. Okay. Got it.
One query,
Okay.
Sneha.
Huh.
Sneha, one query here.
Hmm.
First of all, I need to understand the meaning of the two technical terms. What does codicil mean? From what I understand, codicil is an amendment to the main will. Is that it?
Yes, that's correct.
Okay. Secondly,
Um, you were frozen. I
legatee.
couldn't hear you. Hello?
What does a legatee mean? Legatee,
A legatee is a person who's benefiting from the will, like your
the
spouse.
beneficiary. Okay.
Yeah.
Now, suppose we registered the main will. I registered the main will. Tomorrow,
Hmm.
I wish to only make some amendments through a codicil. Then is it
Hmm.
sufficient for me to then register the codicil alone, or do I need to register again the entire document, main will plus with the amendments?
So you can register the codicil alone, but to avoid confusion, we say that do it pura again. Because if
So the cost,
because
so the cost involved So the cost involved
The
in
cost
registering
involved
a
would
codicil is the same as the whole will itself.
that would depend on the lawyer who's doing it. Some people might
Okay.
take the same, some people might charge differently. That we'll have to check with the lawyer then. But for
Okay.
most of
So
our clients, we advise ki matlab, do it again because otherwise it can lead to confusion. Because when you are not there, this will is going to be read by your family members.
right,
So, so unless they are aware of how many amendments you have made,
right,
it's going to be confusing for them.
right. Uh, so secondly, uh, leave aside the lawyer fees, the cost of registering a main will or re-registering it, or even the codicil, is it all the same? The court fees, I mean,
So around the same only. So
okay,
see, when you register, you will be charged a particular amount, and then when you re-register, you will be charged the same amount again. Because for them,
okay,
it's as good as registering a fresh will.
okay, okay.
For the codicil
And
part, we don't exactly do that, so I'm not aware of it, but we can check with the lawyer and get back. Because we
typically,
generally
typ-
we ask for the complete re-registration. So
got it, got it. Typically, what is the cost involved in registering a will?
so in Mumbai, it is around 5,500 to 6,000 per person.
That is the court fees, the registrar's fees.
That is, yeah, that is
Okay.
the lawyer fee plus like inclusive of everything.
Oh, so
So
so all inclusive lawyer fee plus the registrar's fees.
but
5,500 around, right?
lawyers also charge. So do lawyers also charge based on the asset value?
Not really,
It should
no.
not. Typically, no. Why should they?
Because see, when we send them the will, you will see that we don't mention the details of your assets at all. So there is no way that
Ah,
they know, right? Because
okay.
what we saw upper was that in the financial assets part of it, we are not mentioning your details,
Amounts.
finer details anywhere. So they have no means of knowing what your asset value is.
Right.
Sneha,
So just to confirm,
sorry.
sorry, Vishwa, just one last question to her. So what I understand from you is that typically, on an average, the cost would be
Hmm.
around 5,500, all inclusive, lawyer fee plus the cost of registration, the registering the document, right?
At least
Yeah,
for the clients we do for, that is the cost. Now it depends from lawyer to lawyer.
sure. Got it. Thank you. Yeah. Vishwesh, please, yeah,
Sneha,
you may carry
yeah,
on. Yeah.
Sneha, another thing, when if at
Hmm.
all we decide to go for a notarization, uh,
Hmm.
the bill should be notarized on 500 rupees stamp paper or 100 rupees stamp paper. What is your recommendation?
500 rupees is
500
better.
rupees. Okay.
Is
Okay.
better because recently 100 rupees has if I'm not wrong, 100 rupees has been stopped lately. People
Acha,
don't
it's
use it.
discontinued. Okay.
I
Okay.
think
Fine.
so. People don't use it.
Okay. Fine. Fine.
And Sneha,
And
to
does
Vishwesh's question earlier, his question was uh, between between a will that is notarized and a will that is registered. Which one
Hmm.
has a better uh, authenticity attached to it?
I would say for all our clients, we recommend a will that is registered because, like I said, a sub registrar. So when you go for registration, right, you sign in front of a sub registrar. Then he has the copy of the will. So it's better that you do it in front of him. You
Okay.
you you go there with two witnesses, so he checks everything. So
Okay.
because for the clients that we have worked with, none of them have notarized. So it's all
Okay.
registered only.
Okay.
So
Yeah, the fact that you're also there physically in front of the registrar also goes to prove um, your being of sound mind and being capable and all of that, right?
yeah, because so he doesn't exactly ask you if you're of sound mind,
Yeah,
but
yeah, yeah,
signing it in front of him, matlab, he's a government officer, so
yeah.
so it kind of verifies everything.
Got it.
See, because when you notarize, you are not exactly doing it in front of some government official or some when you do it in front of a government official, he has a record.
Sure.
And it gets more difficult for somebody to challenge that.
Sure.
Right? Any other queries?
No.
So I can now proceed to the trust other thing. So basically, for a trust, also we have. I will share my screen. Just a second.
Can you share the presentation?
Yeah, I'm
Yes.
sharing the presentation.
Yeah.
Just a second.
Hmm.
Right. Okay. Is it visible?
Not yet.
Not visible?
Not yet.
Got it.
Now?
Yeah,
Turning
sharing.
on.
Yeah.
Yeah.
Yeah, we can
Now
see now.
visible? Yeah.
Yep.
Yeah.
So basically, the kind of trusts that we create are called private family trusts. Now, a private family trust is basically a trust which is meant for you and your family members, right? So there are various types of trusts. We have a charitable trust, we have a private family trust, we have a temple trust, but this particular trust that we are concerned with is a private family trust, which is only and only meant for you and your family members, right?
Yeah.
So why do we make this trust? The first part is ring fencing. Now,
Would you mind,
just
Sneha, would you mind pressing F5 on the presentation mode?
sorry, I can't hear you.
Would you mind going on the presentation mode? F5?
F5.
Yeah.
Hold on.
Presentation mode. Presentation mode. I think go to first click on enable editing.
Yeah. Now, can you see?
No.
Not yet. First click on enable editing on the top, the yellow bar.
Hold on. Hold on.
Yes.
I think it's gone off now. I can't see the screen.
Is it visible or is it not visible?
No, your
Not
screen is not,
visible.
it's not visible. It's not shared yet.
Just a second. Yeah. Now?
Yes.
Yeah, it's fine.
Fine.
Yes.
Yeah.
Perfectly
Perfect.
fine.
Okay.
Thank you. Yeah. Go on.
Yeah. Yeah. So, why do we make this particular trust? Now, firstly, the kind of private family trusts that we make, there are two parts to it. So, these are irrevocable and discretionary trusts, right? So, first, I will be explaining irrevocable, like what do we mean by an irrevocable trust? Now, let's say if I make a trust and I put some money in the trust, okay? Now, once I put money in the trust, I cannot take that money back because then that money becomes a trust asset and it is only meant for the beneficiaries in the trust. So generally, people make trusts for for their spouse or for their children, like mostly for the children. So let's say if I make a trust for my child and I put in some money, then when I put in that money becomes a trust asset, and then that money is only supposed to be used for the beneficiary in the trust. So, for example, if my child is a beneficiary in the trust, then that particular trust money will only be used for my child, right? Is this understood? What I mean by
Yeah.
irrevocable? So, I cannot take that money back once I put it, right?
So even the
So,
earnings, so even the incomes on the trust assets can only be used for
any
for the benefit of the beneficiary or no, not for me anymore.
No, not for you. It is only for the beneficiaries. So what we recommend is that, let's say if if you're a family of four, okay, if it is a husband, a wife, and two kids, so the husband, so we have certain persons in the trust. We have something called as a settler in the trust. Settler is the one who initially funds the trust, who puts the initial money in the trust, right? Then we have something called as a managing trustee in the trust. Now, managing trustee is basically the person who's in control of all the affairs of the trust. He is responsible for giving money to the beneficiaries in the trust. So in your trust, you can be both the settler and the managing trustee. And then it is up to your discretion as to when you want to give money to the beneficiaries. They can't themselves take money from the trust. You are supposed to give it to them, right? That is the discretionary element of the trust.
Okay.
Is this understood what I was saying?
Yep.
Yeah.
So,
One more thing, like you said that the settler or the managing trustee cannot use it for himself. Suppose in a scenario like the settler puts in 1 CR, suppose
hmm,
with two children as his beneficiaries.
hmm,
Now, going in the future, possibly the settler himself requires a portion of the money for
hmm,
some emergency or could be anything.
yeah.
He cannot by any chance cannot take that money for his requirement. Even it could be a medical emergency. That cannot be done.
No, no, no. So there is one way out, but you can't do it frequently. So
Okay.
first of all, so there are two parts to this answer. The first part is that we don't recommend you to put more than 30 to 40% of your wealth in the trust. Okay.
Okay.
And the second part is that if you are really in need of the money, you can
Mhm.
transfer it to the beneficiary, and then the beneficiary can put it in your individual account.
Okay.
But you can't do this transaction repeatedly because then it will come under the income tax lens.
Okay. So this is only you're circumventing the thing. Okay.
Right. So if it is, so this is not recommended that you give it to the beneficiary and the beneficiary gives you, because then that could lead to an income tax. This they can get suspicious,
Continue.
and
Okay.
we also, that is why I recommend, that you don't put more than 30 to 40%. 40% is the upper limit. Actually not more than 30% of your total
Okay.
money in the trust. Right.
Okay.
Right. So basically, the first objective is ring fencing. So let's say, like you said, if there is any, unpredictable and unforeseen adversity, and let's say if your personal asset gets attached, like whatever
Mhm.
is in your personal name, that gets attached. Okay. But whatever you have put in the trust, that will still remain, because legally that is not your asset anymore. That is a trust asset. So basically, what happens is when you transfer money to the trust, you transfer legal ownership to the trust, but you still retain control over the assets in the trust. So your family can still have that kind of lifestyle which you were enjoying prior to the liability, right? So for
Okay.
an example, let's say if I have certain amount of money in assets, okay, and I put certain amount in the trust, right? And if there is any liability, that liability will only be on my personal assets and not on my trust assets. So let's say if that, there is any expenditure for my children or anything, I can use that trust money to fund whatever their thing is there. In an event where all my personal assets get attached, I can use the trust money for them, not for myself, because of course I am not the beneficiary. Then if I really need that money, then I'll have to use that transfer route. But then again, we don't recommend that, because that is, so ring fencing is one of the objectives why we recommend a trust, that if any liability comes onto you, then you can use the money in the trust for the beneficiary's benefit. But there is also one particular rider to this, is that you have to then start this trust and transfer this money before the liability comes into picture. Like for example, let's say if a court case is initiated against you, you can't then put
Mhm.
the money, because then that is legally a malified intention. So the court
Okay.
will say that now that there is a case against you, you are going and putting the assets. So that is not allowed. You have to plan this in advance. You have to make sure that the court doesn't point out a malified intention, because then that will not be valid. And there is also a 2-year cooling period. Now, legally, as per IBC, what happens is, let's say today, if I put 10 lakh rupees in the trust, right? So today's date is 12th November 2024. So for the next 2 years, this particular asset can easily get attached. So this is as per IBC. So this asset only gets safe after 2 years. So a court of law can attach this particular asset for the next 2 years. So till 12th November 2026, my 10 lakh rupees can be attached by the court. But after 12th November 2026, the court cannot attach. So there's a 2-year cooling period. And one more clarification that this 2-year cooling period is with every tranche. So, for example, if today I put 10 lakh and then 1 month later I put another 10 lakh, then for the second 10 lakh, that particular date 2 years later, right?
Okay.
Is this understood?
Yeah.
Yes, yes.
Yeah.
Two questions. First, why
Right.
did you say it is only advisable to not to put more than 30 to 40% of your assets? Is there some limit on that?
No, there is no legal limit, but you can't take the
Ah.
money out, no, once you put it.
That's the reason.
You will
So
have to put
one,
it through the beneficiary, and again, which we don't recommend,
okay,
right?
got it.
So there's no legal limit as such. You can put a lot of money, but we don't advise that because then it gets very difficult to take the money out.
You can also transfer immovable property to the trust.
You can legally, but we don't recommend it because what happens, sir, is that when you're transferring an immovable property to the trust, legally it becomes a sale from you
Okay.
to the trust because the trust is a separate entity, separate legal entity,
Okay.
which means
Okay.
which means you have to pay complete stamp duty.
So it's only the financial assets that will get transferred.
Yeah, financial assets, mutual funds, demat, all of that.
Yeah.
So it cannot be done through a gift deed. What? Even that will be considered as a sale.
If it is done through a gift deed, that won't be considered as a sale. No, because it is a gift between you and, let's say your close family. So it won't be considered as a sale. That is different.
So,
Gift deed is different.
so Sneha, help me
If
understand this a bit
can
better.
uh,
Sorry, go on.
so
Agustin,
can a
go on.
person, can the who is a settler, na, the person who, so he can do a gift deed to the trust? Is that a possibility to avoid stamp duty on the movable assets?
Stamp duty is only for immovable property, sir. For any movable asset, you don't have to pay stamp duty.
Sorry, I meant immovable. So can that be transferred into the trust through a gift deed?
No, we don't. That is not how it is to be done.
So what I understand from here is that, and correct me if I'm going wrong, Sneha, we are saying that it is not advisable to transfer immovable properties to a trust through a gift deed because that will attract stamp duty, right?
No,
So it's not
not
that.
through a gift deed. It is not advisable to transfer any which ways. And gift deed say we don't transfer. Gift deed is
Okay,
not the correct instrument to transfer into a trust.
okay. So what I understand is that one should not transfer immovable properties to a trust because that will attract stamp duty. It's
Right.
not that it will be a sale. So if it's a sale, then there's a capital gains tax and all that thing applicable. So when we're transferring it to a trust, a renewable property, there won't be any incidence of capital gains and all of that, but there'd be an incidence of stamp duty, is what I understand. Is that correct?
Yeah.
Okay.
Stamp duty, and then the trust has a taxation of its own. All the assets in the trust are also taxed.
Okay.
It's not as if you transfer to a trust, you don't get any tax exemptions in a trust.
So the trust also has to file its own ITR every year. Is that correct?
Correct. You have to file an ITR every year. Okay. Hello.
Yeah.
Yes. You can continue.
Yeah. Go ahead. Please continue.
Right.
Yeah.
So the next part is that the second objective is estate planning. So estate planning has two parts. One is a will, which we just saw. So a will basically deals with after your lifetime, right? But let's say
I
if you
think.
create a trust.
Sorry, Sneha. I think we missed the second, the previous slide. Can you go back to the previous slide once? I think I
No, I have
saw we
already
missed.
explained the previous slide
Oh,
to
this one.
you.
Yeah. Sorry. Go on. Sorry. Go on.
Yeah. So the second objective is estate planning. So a will deals with whatever is like after your lifetime, whatever your assets are there, the transmission of that particular will, right? But if you can plan your estate while you're alive through a trust, where you can transfer money and then give it to the beneficiaries. So this is the biggest difference in these two documents. A will comes into picture after your lifetime, and the trust enables you to manage your wealth during your lifetime, right? So this
Yeah.
was the second objective. Now the third objective is something called as estate duty. Now, as of date, till date, we don't have any estate duty. We used to have it in the 1980s, but as of date, we don't have any estate duty, right? So what happens is that whatever asset that goes from you to your beneficiary through a will, that is an inheritance in the hand of the beneficiary, right? Estate
Yes.
duty is basically a duty on any form of inheritance, right?
Yeah.
So if you want to avoid some portion of the estate duty, you can do that through this, because a trust, like whatever they are getting from a trust, that won't come under inheritance. That that will be a trust asset transfer to the beneficiary, right? Is this clear?
Okay.
The difference is clear.
Yeah, but then since
Yeah,
there
but
is no estate duty now, how is this currently relevant?
Because most of the developing countries in the world do have an estate duty, and this is a frequent discussion in the Indian government whether they want to start estate duty again or not, and also because it was previously there in the country, which is why this might come in the future, because it has been discussed
So
a couple
yeah,
of
yeah.
times in the budget also.
Okay.
So this might come into the future, because if you look at most developing countries like US, Japan, all of them have a state duty.
Right.
So
One more
this,
query. Yeah,
yeah.
sorry. Yeah, one more query is that once the assets are moved to a trust for the benefit of the beneficiaries, going forward, uh, when I have gone away from this earth, uh, will the assets continue to remain with the trust alone for all times to come, or is there a possibility that those trust assets can be moved to the beneficiaries' individual accounts going forward?
So what happens is once whatever asset is transferred to the trust, right? The managing trustee of the trust, like in case if it's your trust, suppose the managing trustee is you. You at any point of time in the trust can give the money to the beneficiary in his individual account. So let's say
From the
if
trust? From the trust?
yeah, the trust will give the money to the beneficiary in his individual account.
Right. Okay. Yeah. Yeah.
And one more thing, the Vishal sir asked that in case of the demise of the trustee, in case
Hmm.
of demise of the trustee, will the succession will happen automatically, or we have to trigger it?
No, so firstly, to explain the structure of a trust, we have two trustees at all times. That is the legal
Yeah,
requirement as per
yeah, yeah.
Indian trust, right? So one trustee is a managing trustee who is responsible for the entire affair of the trust, right?
Hmm.
The second trustee is just a dummy trustee, on paper trustee, because it's a legal requirement, right?
Hmm.
So what happens is, let's say if the managing trustee dies, okay? So the
Hmm.
kind of trustee that we follow is, we say that after the managing trustee dies, whoever is the beneficiary. Now, in most cases, the beneficiary is the spouse. So the second trustee, not the managing trustee, the second trustee, with the consent of the spouse, can appoint another trustee, because there is no second managing trustee. There is only one managing trustee, after which he dies. The second trustee, with the consent of the managing trustee spouse, can appoint another trustee, because we need two trustees at all times. We can't have one trustee in the trust.
Okay.
So
And can the second, the managing trustee, the reappointment of the managing trustee, can that trustee from the beneficiary? Because ultimately that will be from the close circle only, right?
sorry, can you repeat? I couldn't hear you.
The reappointment of the managing trustee, can it be happen through beneficiary? Means can one of the member of the beneficiary can be again reappointed as a managing trustee?
No.
No,
no,
beneficiaries are
no,
not
no.
trustees. No.
Okay.
Wait. So
So it
what
has to be
happens is,
someone very trustworthy person has to be.
yeah.
Exactly. So that was
So
my
for
point.
example,
And someone should be trustworthy person should be there as a
right.
reappointed as a managing trustee.
But in any which ways, without the consent of your spouse, that person will not be appointed. The consent of the
Okay.
so generally how a trust structure looks like is, you are the settler and you are the managing trustee, and beneficiaries
Hmm.
may your wife and your
Children.
Children.
Can't hear you,
come
Sneha.
into the picture. So let's say after,
Yeah.
sorry, am I audible?
Yeah, you're audible now.
Yeah.
Right now, yeah.
So I was saying that settler and managing trustee, and then the wife and children are the beneficiaries. Now let's say after your demise, if a new trustee has to be appointed in the trust, our trust deed is structured. Our trust deed is structured in such a way that your wife's consent will be required to appoint the new trustee. Okay.
Okay.
And let's say if your wife is also not there, that then your children's consent will be required to appoint the new trustee. So without,
Okay.
so ऐसे नहीं होगा कि आपके वाइफ और चाइल्ड के मर्जी के बगैर कोई ट्रस्टी बन रहा है. It is only with their consent that somebody is being appointed a trustee.
Okay.
Right. Right. But Sneha, my question is that me being the settler and the managing trustee, right?
Hmm.
Uh, my wife and my children are the beneficiaries of the trust. Tomorrow I pass away, right? So there's no managing trustee and settler anymore.
Hmm.
Can the beneficiaries choose to uh, extinguish the trust and not have the trust anymore? They want to have it all in with them anyways.
So what you can do is in the duration of the trust, because the trust requires a duration, correct?
Okay.
It can't go on in perpetuity. We don't do trust in
Okay.
perpetuity. So what you can mention in the duration is that the trust shall be operational for a period of so and so as let's say 25 years, or the lifetime of the settler, whichever is later,
Right.
right?
Okay.
Right. So you can just say that it will be there till my lifetime. So we don't
Okay.
recommend just writing lifetime, because if there's an accidental death, let's say, let's say if we create the trust today and a week later there's an accidental death, and if the term
Mhm.
only mentions lifetime of settler, then 1 week में the trust will have to wind up.
Right.
So we mention that you give a tenure, okay,
Right.
or you give lifetime, whichever is
Hmm.
later,
Right.
right? Right. So we write it like that the tenure of the trust will be 25 years, or the lifetime of the settler, whichever is later.
Right. Okay.
Okay.
Right?
Okay. Right. Thank you. Yeah.
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 And one more thing, if you are the settler and the managing trustee, you cannot be the beneficiary. So legally
Yeah.
this is possible, but it is not a recommended pattern, because what happens is, let's say if there's a liability on you, okay, and the court finds out you have a trust, what the court will say is that because you are the managing trustee, so you have complete signing power in the trust. So what the court will say is that you sign this particular amount ka check and then you pay the court. Matlab you pay whatever your liabilities are. So that is what we don't recommend, because if somebody else is the beneficiary, they can very easily say ki we don't have the power to get money from the trust. It is up to the discretion of the managing trustee, right?
Oh.
Is this
No,
understood?
please explain. No, please explain again. We didn't quite understand that point.
So we do not recommend that the managing trustee and the beneficiary be the same person. The
Right.
reason behind
Obviously.
this is that let's say tomorrow there's a liability on me in court, right? And the court knows that I have a trust and I have complete signing authority in the trust, right? So the court can say that you have so much of money in the trust. You sign yourself a check as because you are the managing trustee, you are the beneficiary. You sign this
Right.
amount ka check and you pay the court, pay the liabilities off.
Right. Right. Right.
What happens if somebody else is the beneficiary is that other person can say that because the beneficiary can't take money on their own in the trust, that the managing trustee has to give. So
Right.
then they can tell the court that it is not in my power, managing trustee will have to give, right? Which is why we don't recommend managing trustee and beneficiary to be the same person. So it is legally perfectly possible, but we
Right.
don't recommend, because it dilutes the whole ring fencing objective that we have,
Exactly.
Right.
right? Understood?
Yeah. Yes.
Yeah.
Yes.
Yeah. So the next part is, so are there any NRIs on this call?
No.
Sorry?
No.
But yeah, you can take this because we deal with NRI, so you can take this here.
So, okay. So what happens is NRIs have certain restrictions to deal in Indian mutual funds as per FEMA and all of the regulations. So what they do is NRIs create a trust because the trust is an Indian entity. So then through the trust, they have all of their investments as a resident. They can do it as a resident because the trust is an Indian entity, right? So this is what gives NRIs an advantage if they create a trust. Right?
Okay.
Sneha, is this applicable to US NRIs as well?
And any form of NRI.
No, the reason I'm asking you is FEMA is one thing. There's another thing that has come up is if a US NRI, a US national, suppose your
Hmm.
citizen is sorry,
Yeah, I'm listening to you.
yeah, US citizen is investing into mutual funds in
Mhm.
an Indian mutual fund,
Mhm.
then they have to do a different filing.
Okay.
So will that be avoidable through if at all a trust is formed over here and the investments into mutual fund is done through this trust?
So for US clients, we don't advise them to be settlers and managing trustees. What we do is we tell them that
Uh-huh.
make your parents as the settler and the managing trustee, and you be the beneficiaries in the trust. So that
Yeah.
what what we advise them is whatever. So for example, if they have any mutual funds in their name, they can
Yeah.
gift it to their parents through a gift deed. Okay,
Mhm.
and then
Mhm.
their parents can transfer, because their parents are the settler and the managing trustees, they can transfer that mutual funds into the trust, and then because that person is the beneficiary, ultimately he can benefit from the mutual funds and everything. That is
So
how we
as
do
a
it for you.
so as a US citizen, he did not declare his global income. Whenever he's declaring his global income, he did not give or make a mention of this mutual funds which he has
No, he
invested
will
through
have to,
trust.
he will
He
he
will
will
have
have
to.
to, he will have to, because US follows global taxation. We can't omit this.
No, if the assets are transferred through gift deed to his parents and then they ultimately end up in the trust, then
Hmm.
this will not get added to his global income, no, because the trust becomes a different entity itself.
Or
Because
it,
now his
then,
assets he has transferred, huh?
hmm, then it's fine.
No, but I think what Vishesh was asking was that having moved the assets to the trust through the parents being the managing trustee, right? The intention is that the US citizen wants to avail of the benefits of the trust, right? So to the extent that the trust is paying him some monies, that is the amount that the beneficiary, who is a US citizen, needs to disclose also to the US authorities. Is that correct?
Hmm.
That
So, sir,
will get added,
there
no?
are two
Yeah.
things. No, so there are two things. Let me interrupt. There are two things. One is that if for US citizen, they have to declare the tax or gain every year, irrespective of they having the realized gain or not. Okay, that is the one thing.
Irrespective of,
So till
irrespective of,
irrespective of they are having the realized gain or not.
right?
Okay, so they have to
Yeah,
declare the notional gain also,
right,
and they have to pay the tax on that if they are
right,
holding mutual fund in India on their own name.
right,
Okay, but if the mutual fund are in the trust via gift deed to the parents and the parents are settler and the managing trustee, then ideally by the trust tool that is considered the resident individual, that is different. That won't get considered in the US citizens global income,
right. But to the
because that
extent
is not
that
a that is not a realized gain till the time it is getting realized and getting passed back to the beneficiary, which is a US citizen. Then that will consider as a global income. But till the time they are into the mutual fund format in the trust, it won't get considered as a global income for the US citizen.
right, got it. So Sneha, I have a query over here. I have a prospect, okay, who is a US citizen holding an OCI card,
Hmm.
staying in India, staying in India for several years, been doing business, right,
Hmm.
in India, right? His wife and his kids are also US citizens, though they are all of though they all have OCI cards, right? Now,
Hmm.
he has to sell his property and all of that, and some part of the property funds will be there available to him for investment. Now, as a US citizen, he can't invest into into Indian mutual funds,
Hmm.
right?
Hmm.
But if he were to adopt this trust method tool, the trust route, right? How can we structure it in a manner such that he or somebody in the family is able to draw upon the funds of the trust for his living expenses in India?
One sec, can
So
I, can
he
I,
is selling property. So let me clarify. He'll get sale proceeds. That amount is available to him for investment. But because he is a US citizen, he can't invest it on its own, right? So if he were to use a trust route, who should ideally be the trustee, the managing
I
trustee,
did.
right?
I
And secondly, sorry, allow me to finish. And since he's going to be living in India, he has to get money in from the trust for his living expenses. So how will he meet that requirement?
I didn't get your question.
Okay, this
So,
prospect
so
is a US
I
citizen.
know the scenario. Vishal said, I know the scenario. So he has one prospect who is a US citizen by the rule, OCI card. Okay, but rightly he is staying in India.
Okay, he has an
Okay,
OCI
currently
card and he's staying in India. Okay,
staying in India, Delhi, Noida. Okay, fine.
okay,
So now he's planning to wind off some properties, overseas properties.
okay,
Okay,
No, no,
and
no.
that will
He's
be
selling it. He's selling Indian property in
Indian
India.
property only.
Yeah,
Okay,
he's selling the
okay. He's
fine.
property in
selling Indian
India.
property. Huh.
Yeah, it was
Okay,
an inheritance which he's selling now because he needs funds for whatever reason, right? So
okay,
some part of the funds will be available to him for
okay,
investment, right?
okay.
Now, given the fact that he is a US citizen, right,
Hmm.
and he will be, and if first of all, I don't know whether or not as a US citizen he is allowed to invest into Indian mutual funds,
No, you're
right,
not
by
allowed.
itself, not allowed, right?
No.
Now, since he's going to be staying in India, he needs funds for his living expenses in India. What can be the best route for him to invest those sale proceeds of the property being sold so that he can continue to live in India, invest it, and continue to live in India with the drawings from the investments of the sale proceeds?
So if he's selling those properties and he gets those sale proceeds and he's investing that money in mutual funds,
Yeah.
then he can do it. He can that is, and if he wants to create a trust, he can. But if he
So,
has if he's a US citizen, so see, only for UAE people do we recommend that they be settlers and managing trustees because UAE laws are very different. For US and UK, we don't recommend that US UK citizens are settlers and managing trustees. We recommend them to only be beneficiaries.
okay. So he doesn't really have anybody else in India who can be his managing trustee. So how do we do that?
So you can put your parents or your brother or any relative.
Okay.
No,
Okay.
If
the last part of Sir's question, no, that he wants to fund his living expenses. So
Yes.
is that possible in this trust format? Because I think you said earlier that you cannot have too many transactions, something like that.
yeah,
Suppose
if
withdrawing,
you're trying to
if the benefit.
so if you're trying to fund a living expense, so it should be for the beneficiary's living expense and not your living expense. That is the whole objective of a trust. Because if you try to route that money through the beneficiary, then that will not be right with them. That can lead to an income tax query. So if you're trying to create a trust to fund your living expense, that wouldn't make sense.
Yeah. So that's why I'm trying to understand as to how to help this person out, right? So Mr. X has property in north of India, sells the property, has cash available for investment. This Mr. X is a US citizen holding OCI card. All of his family members, wife and kids, also OCI card holders. They are US citizens, right? Um, he has to invest the monies that he's getting by way of sale of the property, and he wants to continue to live in India and to incur expenses. So some way by which he can invest that money and get the income from there or something, by which he can live in India.
So Vishal sir, like Sneha said, there should be someone from his family member, from close family member. There should be a settler and managing trustee. Okay, and he can be the beneficiary.
Hmm.
Now this same problem, if we look at it, as if it's an Indian family only.
Hmm.
So the person has created the trust, and his spouse and his children are the beneficiaries. His whole
Hmm.
intention is ring fencing. He is a businessman, and he wants
Hmm.
to ensure that if something goes wrong sometime, his lifestyle should be protected, and his so now suppose he is landed in some problem, and
Hmm.
his assets are outside the trust, his assets are attached.
Hmm.
Now the only thing he has is what is inside the trust,
Hmm. Hmm.
and he wants to fund his living expense.
Hmm.
So as a managing trustee, he can release money to his children or spouse who are the
Yeah,
beneficiaries.
yeah. He can. Yes.
And indirectly, since they are in the same house, they can take care of their lifestyle.
Correct.
But is there any problem if they do it every month? Like it's like, say, they're doing an SWP from the mutual fund assets in the trust.
So see, if let's say I can transfer money to the beneficiary n number of times, there is
Okay,
no restriction on that.
okay,
It is my money. It is under my control. I can give it
okay,
in any percentage as I wish.
okay.
Okay,
And
and
just to
an n number.
understand, the court cannot go after the money of the the money in the beneficiary's account. Can they go after that in order to recover this man's liability?
Uh, the only catch is, like I said, the malified intention part, which I'd explained earlier, and
If that,
the
okay,
2 year cooling period.
if that is clear, then the court cannot
Huh,
go behind.
no.
So when they release the money,
Hmm.
the money will, when the money goes to the beneficiary, from
Hmm,
the
hmm.
trust bank account, it will go into the beneficiary's individual account, isn't it?
Correct, 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 correct.
Oh, okay.
Right?
Hello, Sneha.
Hello. Huh.
You made a mention that a US citizen cannot invest in Indian mutual funds.
Hmm.
I don't think that is true. I mean, they can definitely invest from their NRE account or NRO account, whichever.
They may be
But
able to, but then there will be significant restrictions on that investment.
no,
It is not
the thing
same as.
I'll tell you, the only problem that they might face is they have to give some, the taxation is different, which it's known as PFIC taxation, which they have to adhere to, and which is slightly tedious. So that is, and if most of the Indian citizens, Indian nationals over there of Indian origin, in fact, definitely have investments in India through mutual fund. Only thing is, many of these people don't really declare.
So then that is
Uh,
a separate issue. If they are
no,
not
no, but
declaring that.
but if even if you declare, it is not illegal. The only thing
It
is
is
you have
not
to
illegal.
declare.
Hello?
Hello, can you hear
Huh.
me?
Vishwesh, go on.
Yeah.
Yeah. The only thing is they have to adhere to the PFIC taxation that is there, which is a bit tedious. Hello.
But for taxation related queries, maybe Akshay, you can connect them to somebody from the tax team then,
No,
because
no,
No,
I'm
no.
no.
not
So
exactly.
we
PFIC
are aware of the
taxation is not
taxation
over
part.
here. It's a US
Yeah,
taxation.
yeah, yeah. So Vishwesh sir, that is a different thing. Okay. So Sneha,
No, no.
yeah.
Okay, let's not get into that.
Let's not get into that. Meanwhile, anybody has any other question regarding trust formation or any other special cases regarding their client? Those that cases they want to discuss here with Sneha, since
Yeah.
Neha allotted so much time with us, so we
Yeah.
can utilize that.
I have a simple question. Okay, NRIs, definitely there is an advantage. Like, for example, if at all they go through the trust route, I believe they will be able to invest in MFDs, but MLD, sorry. But in if at all it's an Indian resident, what is the what are those one, two, three advantages that we can pitch? That okay, you have to if you go through the trust, these are the advantages that will come out of it. I'm
The
specifically talking
advantages,
of yeah.
the
I'm talking
advantages
of
for an Indian resident, I've already mentioned that you can ring fence your assets, you can prevent estate duty, you can go through estate planning while you're alive. So for Indian residents specifically, these are three advantages you can go through, like you have basically,
okay.
right? What I was explaining earlier, with the ring fencing aspect, the
Yeah.
estate planning aspect, and the mitigation of risk of estate duty, these are all advantages of having a trust. If you're an if you're an Indian resident.
Okay.
Okay, so
Right?
one question.
Yeah.
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 Yeah. Go
So
ahead. Go ahead,
suppose
Abbas.
if the yeah, if suppose if the settler dies and the
Hmm.
beneficiaries are spouse and two children.
Hmm.
Now the spouse can become the trustee and can that change happen? She will no longer remain the beneficiary. The children will remain the beneficiary. She becomes the managing trustee. Is that possible? That change.
She will not be the managing trustee. And
Hmm.
why make her the trustee when she is a beneficiary in the trust? I mean,
Because suppose in some case, if they don't want to trust any other family member with becoming a managing trustee, so can this in the deed itself, it can be done that if the settler dies, the option that the spouse can become the managing trustee and the children will remain the beneficiary. It can be incorporated at the formation of the trust.
well, that is possible, but then again, like I explained, why we don't keep the trustee and the beneficiary as the same person, the liability aspect of it.
Hmm.
So we
And
will
one
have to
more
But
thing
the
remove.
is
spouse
that
may not
no,
have
no,
any liability.
Agastiji,
The liability
Agastiji. One
was
more thing is that once the spouse becomes the trustee, she won't be a beneficiary. Then the
yeah, she
beneficiary
will not.
settlement won't be
Yeah,
in her account.
So you
right,
want to
right.
remove the spouse as a beneficiary and make her the trustee? Is that what you're saying?
Right. Is that possible? If the main
Yeah.
settler
So,
dies,
but to remove a beneficiary, you will need the consent of the spouse and the other beneficiaries. So let's say if I
Acha.
want to remove
Okay.
the spouse as the beneficiary, I will need her consent and the consent of the
Hmm.
two children in the trust who are the beneficiaries. Okay.
Okay.
So that is
And
necessary,
then
and we will.
she can be made the managing trustee then.
No, she will be made a trustee. Managing trustee is only the person who first. उसके बाद there is no managing
हाँ
trustee.
हाँ
उसके बाद
but if he
everybody
is
is
no
the
more
trustee.
but अच्छा but if he is no more then who will take his place to do the take the main decisions of the fund
See,
distribution.
so what happens is when the managing trustee is alive, he takes all the
Hmm.
decisions. He doesn't have to consult anybody, nothing. Okay. After the
Okay.
managing trustee dies, there are
Hmm.
trustees in the trust who have to consult the beneficiaries and take a decision. That is how it changes.
Okay.
So, which is why
Okay.
they don't remain managing trustees in the legal sense of it, because
अच्छा.
managing trustee is an independent person. He doesn't need any beneficiaries' consent, nothing.
Okay.
Right? So
So
that's the difference.
the trustees cannot do anything without the consent of the beneficiaries in such
Yeah.
scenarios.
Yeah, the trustees, not the managing trustee. Managing trustee,
Right.
complete distinction.
Right.
So which
Got
is
it.
why I am trying to distinguish the two terminologies, because
Okay. Yeah.
trustee needs to take consent. So when you are
Hmm.
alive, you will have complete authority in the trust. But after
Hmm.
you're alive, आपके बाद जो भी आता है उसको आपके spouse को consult करना पड़ेगा, और अगर आपकी spouse नहीं है, तो your children,
Hmm.
he will have to consult your children before taking any decision in the trust. Okay.
Hmm. But is there a possibility like the beneficiaries want some money and the trustees don't sign or they don't authorize that? So that can lead to a problem. The
So
managing trustee is no more. The settler is no more.
hmm. So what happens is that beneficiaries have the authority to change or remove the trustee also.
O- Okay, good.
So we have a clause where we say that the managing trustee can never be removed. Okay, so you don't have to worry about the
Okay.
beneficiaries trying to remove you during your lifetime. But
Mm.
after your lifetime, we do give that choice to them that they can remove anybody they want. They can
Mm.
remove, they can make them resign, whatever, change the person,
Got it.
right?
Got it. Got it.
Okay. Next
Sneha, just
is
And
a
yeah, yeah, sir. Sorry.
Sneha, you just in your earlier response mentioned about two things. So the first time when when you mentioned you mentioned about settler and managing trustee, but
hmm.
in your last conversation I heard about also being a trustee as well. So a settler, managing trustee, and trustee. So difference here between a managing trustee and trustee.
So managing trustee, like I explained, has complete powers and discretion in the trust. Okay.
Right.
So second, so we have two trustees at all times. So we have a managing trustee and a trustee.
Ah, okay,
Managing
okay,
trustee
got
has
it.
complete authority.
Ah,
Trustee is only dummy. Matlab, he doesn't have any
yeah, yeah, yeah.
authority.
Right, right.
Because on
Got it.
paper we need two trustees at all point in time. So we appoint the second trustee.
Got it. Got it.
Right? Right? So when you are alive and you are the managing trustee, second trustee is merely a dummy trustee. उसके पास कोई authority नहीं होती है. Okay.
Okay.
This is just to comply with a legal requirement that we are putting two people as trustees. Okay.
Okay.
And after your
Okay.
lifetime, of course, like I explained, beneficiary's consent is necessary for any decision in the trust.
Okay.
Okay.
Right? So
So
this
you
is
Also,
how.
you
is
were
there
asking.
a yeah, is
Sorry.
there a clause that is sorry, is there a clause that takes into account, say, in a car accident, all the, everyone is, dies, or the
Mhm.
beneficiary is the settler
Mhm.
is no more. Then is
Mhm.
there a clause to take care of such an eventuality?
Yes, yes, we do have a disposition clause in our trust deed where we state that, let's say, so whoever is the beneficiary in the trust, for example, if your wife is a beneficiary, so we say if your wife is not there, it goes to your
Hmm.
kids. Okay.
Hmm.
And if let's say your kids are not there,
Hmm.
then if your kids have kids, to those kids. And if let's say your kids don't
Acha.
have kids, then to any future legitimate children they might have,
Acha. Okay.
right? Right?
Hmm.
And let's say अगर
Hmm.
इनमें से कोई भी नहीं है, kids के भी kids नहीं है, future legitimate
Hmm.
children
Hmm.
नहीं है,
Hmm.
only in that
Hmm.
rare scenario will the trustees decide whom this money will go to. It's a very rare scenario.
Acha.
Generally, most people
Okay.
do have somebody.
Hmm. Hmm.
So, okay. So
Or
this is
maybe
how
you
the.
can also define that if the kin is not there, the children's children are not there, maybe there will be someone the trust wants to give to. Maybe that can also be defined and said, if no one is there, then this person.
So generally, what happens is in our deed, what we say is wife not there, children not there, their children or future legitimate children. And if none of these
Hmm.
people,
Hmm.
if wife, children, none of them, then in a manner that will be decided by the trustees. That is how we write it.
Hmm. Okay.
So
Okay.
generally, that is how we write it. That is how we phrase it.
But we can make some modifications in that and put also another.
See,
Uh, in
you
case, see, I'm
can.
talking about a scenario. I'm talking about a scenario. Say the children are not married, all are
Hmm,
traveling, and they all had there was a car accident, and everyone is gone. So no
hmm.
children's children, and in such a scenario, the trustee, there should be some clause to say that, okay, if such a thing happens, then my sister or my brother, the trust gets dissolved and everything goes to my brother and sister, or something like that.
Can
It can
be,
be done,
but
no, that kind of.
not advisable.
Okay.
And why
Not
not?
advisable because it is. So what
Then there
happens is
can
when you're
be a moral hazard.
not just a moral hazard. What happens is that when you're talking about your wife and daughter and everybody, you're talking about people
Hmm.
within the trust, which is why you
Hmm. Hmm.
don't
Hmm.
require the trustee's permission. But if it is a
Okay.
person outside the trust, so without
Hmm.
consulting the trustees, because this is something the trustees of the trust have to decide. So without
Hmm. Hmm.
consulting
Hmm.
the
Hmm.
trustees of the trust, saying directly
Hmm.
doesn't I I am like,
Okay.
it is not something which is permissible in my opinion. Like, you need
Hmm.
to, like,
Okay.
the trustees need to be
You
kept in
need
a
to
loop,
have
no?
consent.
Hmm. Which is
Ha.
why we say in a manner which
Okay.
is determined by the trustees. So in practice, this happens
Okay.
very rarely because generally kids do have kids and there are legitimate children, and trustees ka
Hmm.
discretion only comes into the picture only if all the four parties are not there.
Hmm.
You know, कोई ना कोई अगर मान लो आपकी वाइफ अगर
Hmm.
है तो वाइफ को वाइफ का एसेट्स रहेगा. So that will not come into
Hmm.
picture till everybody is dead basically.
Hmm.
Okay, so this is the structure that I explained throughout the presentation, that there's a settler, right? And there are
Hmm.
beneficiaries and there are managing trustee and trustee, right? So settler basically is the creator of the trust and who contributes to the trust corpus. The managing trustee is basically who manages the money in the trust operations, right? So in most cases, settler and
Hmm.
managing trustee is the same person, and it makes logical sense also. So for you to put your money and manage it, right? And second trustee is just a dummy trustee. Beneficiaries are wife and children
Perfect.
generally. Matlab, as per Income Tax Act, only close blood relatives can be beneficiaries in a trust. So niece and nephew do not come under close blood relatives. This is just for your information. You can have brother, sister, like brother, sister, real brother, sister, mother, father, and spouse and kids. You can also put your spouse's family here, spouse's close family. But niece and nephew will not
Okay.
come under this
Okay.
because
One more thing,
this is
Sneha.
defined. Hmm.
In case of the NRIs, for example, suppose if NRI want to create a trust, so there should be a resident individual should be a co-trustee, right, or trustee.
Sorry, I can't
So
hear you.
if any NRI wants to create a trust, okay,
Hmm.
then there should be a resident individual should be a trustee, right?
Right, correct.
So is there any criteria for that resident individual? Is there any blood relatives or anyone can be a trustee?
As long as that resident individual has an Aadhaar card and a PAN card,
Okay, so there
that
is
is
no criteria.
no criteria as such. He needs
Okay.
to have an Aadhaar and a PAN card.
Yeah,
Right.
on the part which is on the right of the green box, which says money is managed, including distribution at trustee's discretion. By trustee over
Hmm.
here, we mean the managing trustee, right?
Yeah, we mean the managing trustee, and after the managing trustee, the trustee plus beneficiaries consent.
All right, got it.
So after the like managing trustee dies, trustee only will take decision, but trustee cannot take a unilateral decision basically.
Got it.
Beneficiaries will have to consent to that essentially.
Okay,
It's
okay,
not like the beneficiaries will run the trust. Trustee will only run the trust, but they will have to be consulted by the trustee. Beneficiaries will have to be consulted by the trustee. Right?
sure.
Okay. So the next slide is just basically how to fund the trust. So
Before we go
from
there,
the
just before we go there, in the objective 3 slide, there was a PDF attached at the bottom left. What is that about?
just a second, I will check.
Yeah,
Uh,
yeah, this
hold
this
on.
PDF on the left, bottom left.
Yeah.
It's not shareable anymore. Huh?
So this is just an explanation of whatever I've just explained to you.
Okay,
It is like not nothing. It's just a flow of what I was speaking essentially.
all right, okay, okay.
Yeah. So,
Can you go
Sneha,
back? Could you?
just a question.
hmm.
Okay, we have understood the structure of a trust, but I mean, we are since we are in this industry, we do hear about HUF also. So HUF,
HUF,
Hindu Undivided.
HUF,
How does it
HUF, yes.
compare? How does it compare with a trust? And where is HUF more advantageous? What are the benefits? Can you just give us some idea about HUF also? I know this is not a part of today's discussion, but still a question came up in my mind that, okay, how is HUF vis-a-vis a trust?
So just to answer that question, there are a lot of differences between an HUF and a trust. And a trust is more flexible than an HUF because see, an HUF is a Hindu undivided family. So in
Yeah.
a Hindu undivided family, in HUF you have something called as co-partners who have a share in the HUF by birth, right? So in a trust, you have the discretion of deciding who will be in the trust. In an HUF,
Okay.
you don't have the discretion of deciding who is going to be in the HUF. So it can be
Yeah.
like multiple members, which is why even in the will draft that we have, we say my share. क्योंकि पूरा HUF आपके ownership में नहीं आता है. There are multiple people in the HUF. So trust gives you that discretion that you can give it to so and so people as beneficiaries, but HUF will not give you that discretion. HUF, you will just be a member of the HUF. Trust me, you can be the managing trustee and have sole control of the assets. That's the difference.
Okay.
And also in an HUF, it gets very difficult. Like if there's a dispute, it it gets very difficult to remove somebody because they have that right by birth. It's very difficult to legally eliminate a co-partner. Beneficiary, if you want to remove, you will need like even that is more difficult, but it is not impossible. You can remove. That is the
But
major difference.
the purpose of a HUF and a trust is the same, basically ring fencing.
No, HUF doesn't ring fence the assets. No,
Doesn't ring fence.
no,
Oh,
no.
Okay.
I wasn't
No,
aware
no,
of that.
no. So yeah. So
Okay.
any other
Yeah,
questions?
you
Because
can continue. Yeah.
no, this was the last slide because the other slide is
Okay,
just the
okay.
structure which I have already explained to you.
Funding of the trust was.
Yeah. So this
Funding of the trust.
the trust
Uh,
comes under any particular act.
uh, the rules are mentioned under Indian Trustees Act 1882.
Okay.
Yeah. So the legal requirements that two trustees have to be there at all times and managing
Can you
trustee,
share the
all
screen?
of these. Just a second.
Yeah.
Right. Is it visible or is it not visible?
No,
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 not
not
yet.
yet.
Hold on. Right. So basically, how to fund the trust. So financial assets, money. So how the money goes is from the settler's bank account to the trust bank account, which I've already explained. Right. And if there are
Yes.
any investments also, so this is financial assets, money from bank account to bank account, and any
Hmm.
investments like mutual funds from demat to demat. Right. So, like I explained earlier, for the property transfer, there is no tax implication, but a full stamp duty is applicable. Right.
So, like the second statement, investment, the settler from the existing demat account can transfer his holding to the trust demat account.
Correct. Correct. Yes. Yes. Right.
So in the first two also, there is no income tax implication at all, right?
From the settler's bank account to the trust bank account.
Yeah, and demat account and demat account.
It is there, like it isn't exactly a tax, but it is a fee of some 0.00 that depends from bank to bank.
Okay.
That
No, that's
transfer,
okay. That may be a bank charge. That's fine. I'm only
yeah,
talking about the income tax implication for financial assets and for investments, bank account to bank account and demat account to demat account. There is no income tax implication as such, right? For either of
no,
the two parties, the
no,
settler as well as the trust, right?
no, no,
Yeah,
no.
okay. Okay.
And one more thing, Sneha, if the settler is a NRI, then can he
Hmm.
shift his existing demat holding, which is into his name as a NRI, into trust, because trust is considered a resident entity. So can he transfer this existing from the NRI holding to the trust holding?
He can, but it would be advisable because if he's an NRI, he will be the beneficiary in the trust, right? Like through the structure that we
Ah,
follow, we are making an Indian
oh.
person as the settler, no? So he has
Mhm.
to first transfer it to his parent or whoever is the settler, and then that person will pump it in the trust. That is how we are trying to move it, no?
Okay.
Understood. So as a beneficiary, he can't transfer his holding to the trust.
No, beneficiary can't put money in the trust. If the
Okay.
beneficiary wants
Okay.
to put money in the trust, he has to give it to the settler, and then that person will put the money into the trust,
Perfect. Perfect. Understood.
right?
And
Then
the slide it was mentioned about tax slabs. Slabs are not applicable. Can you just explain that point?
Can you share again?
So,
Sneha, it is.
Taxation.
so what happens is that capital gains tax, how we are taxed, it is the same for the trust. It is the same as applicable to individuals,
Same,
right?
yeah. Mm.
But जो हमें slab rate benefit मिलता है as individuals, that the trust does not have. Like whatever 5 lakh,
Oh.
7 lakh slab rate benefit that we get,
Hmm.
that
So what is the
you do not
tax rate on what is the tax rate
it is
available?
taxed at the maximum marginal rate trust
Okay,
at around
30,
30%. It is a
30,
large amount.
33, yeah. Mm.
So
Okay.
so there are, so there is no slab rate benefit. The capital gains is the same as how you would pay for an individual, right?
Mm-hmm.
And
So mutual funds work out very well. It will work out very well in a trust format.
So equity mutual fund is
But
flexible to work out very well. Debt mutual fund won't work out very well because debt
because the
eventually get
tax
taxed
rates
at
are
30%.
yeah,
Yeah.
at 30%, right?
Yeah.
right.
Got it.
So the last part is just the registration cost of the trust. The registration cost of the trust is 25,000 rupees. And then the annual
Hmm.
filing depends on how much your CA charges you. That is from person to person, right? And how you basically, so once the trust is formed, you have to apply for a PAN in the name of the trust because the trust is a separate entity, right? So you will apply for the PAN, then you will open a bank account and a demat account in the trust's name. Then you will transfer money to the trust, and then the trust can start functioning. And then when you want to close the
Okay.
trust, you just surrender the PAN
Hmm.
and you close down the
Okay.
accounts, the bank accounts,
Okay.
right?
Got it.
And how much time normally it takes from the since the initial discussion to the formation of the trust? How much time it will take?
In creating the trust deed,
Yeah.
it can take up to a week's time, a week or 10 days time.
And formation of trust?
Formation of trust after registration, then it depends on how soon you apply for a PAN card, how soon you open the bank account, how soon you go ahead and
But normally, as per your experience, now you are doing it regularly and you did it.
most people apply for the PAN card immediately after they receive the copy of the trust deed.
Mhm.
Once it is registered, because we send the trust deed for registration, that like once the deed is registered and you get a copy from the registrar's office, they immediately PAN application form is 49A, right? So you fill in 49A, you apply for a PAN, and you open a bank and a demat account in the trust's name, and then you start basically.
Okay.
And how long does it take for the PAN card to be issued?
That depends on the person, matlab, the authority who issues the PAN card.
Normally, PAN card time is 7 to 15 days. 7 to 15 days PAN card.
Right.
Anything else? Any other question?
No, but Akshay,
All my questions are
we
answered.
need
Yeah.
to, Akshay, we need to see as to what we can do about this case of mine. Huh?
Yeah, that is a bit of tedious case, so that will that will take offline. But as of now,
Yeah.
for the Sneha, do we have any questions?
Yeah.
Vishwesh sir,
Yes,
Bharat
yes.
Ji,
Yeah.
sir.
Thank you,
It
Sneha.
was at least a good insight into this trust formation thing.
Yeah, very good, and thank you, Sneha, for allotting so
Welcome.
Thanks
much
a lot.
almost 1.5 hour time
Yes, yes.
and clearing all the thoughts
Yeah,
of my
but
mind.
Thank you.
Be
Thanks
very
a
a
lot.
lot
patient.
of details, lot of queries got answered. Thank you for answering all our queries.
My pleasure.
Thank you for your patience,
Thank
Sneha.
you.
Thank you for your
No,
patience
no,
and
no.
your. Bye.
I shall take your
Okay,
leave
Sneha.
now.